You need a specific color?
No, just show where he needs to sign.
Because when you print that out, that's gonna be black. Really wouldn't have done that.
Just don't have the red.
Can do it.
All right. Can you look at something real quick?
I'll be seated.
Cody's Browns.
You were right. You were right about it.
Sure it does. It does. And that's why I picked
I don't know
it
if
up.
No, it's all Ariana. It's so right.
And they do a great job.
More voluntary situation.
Oh, call them something different than what's for.
Y'all are here for arraignments.
everybody here to be arraigned, raise your hand, please. Okay. Everyone here for arraignments, you have the right to know the charges against you, right to remain silent, right to an attorney. If you can't afford one will be appointed for you. And you may be offered a plea by the state, and you can get your case resolved today. If not, it'll be continued to a later date. So, Lacey offered,
We took care of her this morning, Your Honor.
David Bradley, all right, this is 24 CF 1841, State versus David Bradley. Mr. Bradley, you're charged with aggravated battery using a deadly weapon.
This is just your copy of the charges. Your Honor, Tim Gibbs, I'm sorry, go ahead.
Appointed public defender, go ahead.
Yes, Your Honor, I had already been appointed to represent Mr. Bradley. Tim Gibbs, Public Defender's Office for Mr. Bradley, 24 CF 1841. I don't know if the state had an offer on this one as of yet. If not, we'll plead him not guilty.
I do, but it's 4 years DOC.
4 years DOC. We'll enter a not guilty plea, then judge requests 15 days for pre-arraignment motions, demand trial by jury.
October 28th.
So right now. Unfortunately not today, because we have to give notice to Ms. Draywick.
Thank you.
Thank you, Judge. I'll come out.
Randy Cooper. All right, Mr. Cooper, you're charged with felony theft, 2 prior convictions. Is there an offer for him?
Yes, Judge, the offer currently is an adjudication of guilt, 18 months DOC, 515 court cost.
We'll enter a not guilty plea, Judge. Request 15 days for pre-arraignment motions, demand trial by jury.
All right, October 28th, thank you.
Yeah, October 28th.
Deborah Davis.
Seeing no response, Your Honor.
Andrew Gromley.
State would ask for a capias on Deborah Davis, Judge.
No bond capias. Andrew Gromley.
We addressed Mr. Gormley this morning, Your Honor. He's already in DOC. We'll be working on getting this case resolved if we need to by Zoom at a later date if the court approves that.
Shelby Green.
I believe she was transferred to Division I earlier today. That's fine.
And my colleague is correct about the transfer.
She has already been transferred.
Yes, Your Honor. Your Honor signed an order earlier today transferring this case to Division I since she has a pending case there
She
already.
needs to be set for rearrangement, I guess.
I believe that order covers that.
Okay, thank you.
Thank you, Judge. So you're going to get down in for one for all your cases. Yeah.
Shaquem Hall.
Here, Ms. Green.
Shane Jahab, or Joghab.
Judge, this is my case. Mr. Joghab, Shane. Judge, he doesn't answer the call of the
this-
court, and I
who's
don't
this
see where we've
coming
had
in?
in contact.
Somebody just walked in. What's your name, sir? Your name?
John Smith?
Okay. No bond capias for Mr. Joghab.
Thank you, Judge.
Danny Mason.
Judge, this is a case that we called earlier. I did print out the offer.
Mr. Mason, will you please raise your right hand and be sworn? You swear the testimony you give for this court's true, so help you God.
Yes, sir, I do.
Thank you.
All right. If this is what you want to do, be time served on this. 3 years probation on the felony counts already concurrent. In the case with damage, to be $3202 restitution and $100 a month. And I went over that with you last night. This is what you want to do. I need to get your signature right here. Do you mind if I date it for you?
No, sir, I do not. Thank you.
Oh, sure. You've got a bunch of sheets where it just printed out a couple of lines and then went to the next one. That's why it's so thick.
I hate when that happens.
Check, make sure that it should be printed out extra lines. I'm looking at the front of it. Now, you need the judge's signature pages on just one page. There you go. Defense and I were talking about how it, score sheet printed out kind of funny with stuff being split over several pages that normally would be on one.
All right, Mr. Mason, you want it. This is State of Florida versus Danny Mason. In case 24-1549, you want to enter a no contest plea to third-degree felony, fleeing, attempting to elude, and count 2, driving license suspended or revoked, a second-degree misdemeanor. And in 24 CF 1815, count 1 through 7, violation of risk protection order, 7 counts. And in 24 CF 1818, theft or tamper with the utility cable, third-degree felony. So you want to enter no contest, plead all those charges?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Did anybody force you or threaten you to enter this plea?
Not to my knowledge, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Not to my knowledge, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. On all the misdemeanor counts in each case, you're judged guilty since the time served. In each felony count and each case, you're judged guilty since the 3 years probation on each count concurrent, 515 court costs, cost of prosecution and PD fee. In 24 CF 1818, restitution of $3,202 at $100 per month. Adjudicated guilty, all cases, all counts. Okay?
Yes, sir.
Anything further?
No, Your Honor.
Please waive, Your Honor.
Yeah.
That's $100 a month?
That's correct.
Yes, sir.
Thank you, Judge.
All right, thank you,
All
sir.
right, good luck to you.
Yes, sir.
Hunter McKenney. All right, Mr. McKinney, you're charged with retail theft, $750 or more, driving license suspended or revoked, 4 counts, attaching plate not assigned, 3 counts, and looks like, is that a resisting arrest?
I don't have a,
It's resisting a retail merchant, Judge. It's sort of the shoplifting form of resisting.
Okay, resisting a retail merchant.
Yes, sir.
the offer in this case, Judge, is an adjudication of guilt, 12-1 DOC, 515 in court cost.
Judge, I went over that with him yesterday when I met him at the jail. We're not prepared to enter that plea at this time. I'll enter a plea of not guilty on his behalf. I request 15 days for pre-arraignment motions and trial by jury.
I'll take that.
You are going to take
I'll
that?
take that.
Okay. All right, Judge, I stand corrected. He says he wants to take that.
Take that.
All right, with credit for time served.
Let me craft something up for him unless you just want to do an oral plea colloquy. This is sending him to prison.
I think
12.1, right?
we need a score sheet.
I got a score sheet, Judge, we
All
would
right.
request it
Mr. McKenney, would you,
boiled down to writing.
Mr. McKenney, would you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir, I do.
All right, you want to enter a no contest plea to those charges that I just told you were charged with?
Yeah, no contest, yes, sir.
Are you aware of the rights you're waiving while, by entering this plea? Right to a jury trial, right to remain silent, right to have attorney represent you during trial?
Yes, sir.
You can put your hand down. And other rights that I haven't specifically gone over, but you're aware of all the rights you're waiving by entering this plea? You are?
Is that a yes?
Yes, sir. The restitution, I go to prison, it's gone, right?
No?
Correct, we're not seeking restitution.
Okay, not seeking restitution, okay.
Yes, sir.
And are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty in all cases, all counts. In the misdemeanors, if there are in some of these misdemeanors?
Yes,
attaching-
Judge. 9, I believe, is a misdemeanor. Well, actually, the GWLSs are all second-degree misdemeanors. The attaching improper tags are all second-degree misdemeanors, and the resisting a retail merchant is a first-degree misdemeanor.
I'll sentence them to time served on the misdemeanors. A judge guilty, and on the felony, 12.1 months Department of Corrections, concurrent with credit for time served.
Thank you, Judge.
Standard court costs, and that will go to judgment,
Yes, sir.
okay?
Sir.
All right, Mr. McKenney, do you want to take this? It's yours. You don't have to.
Score
but it's
sheet?
yours.
Yes, Judge. This thing for a reason.
Okay. Yeah. Judge, I believe I have Audra Meeks remaining. She's out of custody.
Okay.
Ms. Meeks, come on.
Audra Meeks.
Ms. Meeks, here's your copy of the charging document. Judge, I'm in a plea of not guilty on her behalf, request 15 days pre-arraignment motions and trial by jury. This is likely to be worked out eventually, but we're not in a position to do
All
that
right.
at this
She's
point.
charged with battery on what facility staff?
Yes, battery on a law enforcement officer, firefighter, EMS, or other specified personnel. ER personnel would be within the specified personnel.
Okay. October 28th.
Thank you, Judge.
Kavon Prince Robinson.
Okay. Yeah, just call and make an appointment this evening, okay? Oh, you're welcome.
Mr. Robinson, you're here for arraignment. Come on up. You're charged with possession of more than 20 grams of marijuana, a third-degree felony, and possession of narcotics equipment, a misdemeanor. You have the right to know the charges against you, right to remain silent, a right to a jury trial, a right to an attorney. You can pay for your own, or if you can't afford one, a public defender will be appointed. The state may have an offer for you. Let's see what they got.
The state's offer is just for the possession of marijuana greater than 20. It'll be an adjudication, credit for time served, $6.15 court cost. So no jail, no probation.
And you dismiss the misdemeanor?
Yes, I didn't file on it.
Okay, so what they're offering you is they're not going to charge you on the misdemeanor, possession of narcotic equipment, on the marijuana. If you want to plead, I'll judge you guilty, sentence you to time served, no more jail, no probation, $6.15 court costs. I'll give you 180 days to pay it before it goes to a judgment. You want to do that? Would you please, this is Kavon Prince Robinson, would you please raise your right hand to be sworn? You swear the testimony you give for his court's truth, so help you God. This is 24 CF 1806, State, Florida versus Kavon Prince Robinson. You want to enter a no contest plea to possession of more than 20 grams of marijuana? You wear the rights you're waiving by entering this plea, your right to a jury trial, right to make the state prove its case beyond a reasonable doubt, right to cross-examine witnesses, right to an attorney. You're waiving all those rights and others. You understand that? You do? Has anyone forced you or threatened you to enter this plea?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it, judge you guilty, sentence you to time served. No other jail time or probation, 615 court costs, 180 days to pay it before it goes to a judgment. Okay? Thank you.
Yeah, approach judge out of score sheet.
All right. Robert Jeffrey Scofield. No bond capias. Is there anyone here for arraignment that I didn't call? Come on up. What's your name, please?
Shane Jacko.
Okay, we called you.
Oh, I apologize, sir. I was,
I'll withdraw the capias. Public defenders indicated. Yes.
I have an offer if the defense hasn't received it yet, which is going to be an adjudication of guilt, credit for time served, 12 months probation, $6.15 court costs, and a substance abuse evaluation and treatment.
All right. So basically, you would be on probation for a year, have to get a substance abuse evaluation and treatment. Do you, with the withheld, you would not have a formal conviction for it?
Correct, yes, sir.
Do you want to do that, or do you want me to plead you not guilty and you and I come in and talk about the case? And
I guess I would like to, be able to meet with you, of course, and see what you have, and then, I guess ask for a continuance and see what we may be able to do.
well, it wouldn't be a continuance.
Whatever it may be.
For today's purposes.
Yes, sir.
Judge, he wants to meet with me first. Has that been sent over in stat?
It should be.
Okay.
It'll stay open as well.
All right, I'm going to give you a card, sir. I'm going to instruct you to call and make an appointment.
Yes, sir.
To meet with me. Generally speaking, I do my appointments on Tuesdays. If for some reason you need a separate day or a different day, just let the secretary know, and she'll contact me and we'll make arrangements,
Yes,
okay?
sir.
October 28th.
Thank
Yes,
you,
sir.
Judge.
Thank you, sir.
Thank you. All right, we're here for, well, we're still we're early. Case of 2016 CF 2013, Samuel Mosley has been continued, correct?
That is correct, Your Honor. Does the court or the clerk have a new date for that?
I don't yet.
Okay. Should we check with Madam Clerk later, or do you have one?
What about, like, November 7th? Is that too soon?
I think that would be fine, Your Honor. I believe Mr. Harper said November would be fine, and I believe the essential witness that I need, Mr. McKenney, is also available. So
All right, if you wouldn't mind.
Just grab that day.
Yeah, send me an order, please.
Thank you. I'll let Mr. Harper know.
Ready to go on Daniel Kilburn?
Yes, Your Honor.
We're a little early, but
I think everybody.
all right.
Madam Clerk, do you have any exhibit stickers?
I do.
Judge, we're ready to proceed.
All right, go ahead.
Judge, we would like to, oh, this is here on Mr. Kilburn's cases. Case numbers are 17 CF 3565 and 21 CF 452. If the court will recall, this was the case where we entered into a plea agreement on July the 1st. We postponed sentencing until August 8th. On August the 7th, defense filed a motion to withdraw plea. When we came into court on August the 8th, we didn't have any witnesses testify, but we made our arguments. The court ruled that you were not going to let us withdraw our plea, and you went ahead and sentenced according to the plea agreement. I filed a motion for reconsideration, just asking the court to reconsider its original ruling on our motion to withdraw plea. With the court's permission, I have a couple of witnesses, just so I can get some information on the record.
What does the state say?
Your Honor, we would object to the defendant being allowed to withdraw his plea. This was a negotiated plea. We went over all the details. We don't believe that there's going to be any showing of a manifest injustice as to the plea being allowed to remain in place, so we would object at this time.
And he's out of, I didn't send him to prison, right?
What happened, if the court will recall, the plea bargain was essentially judged X number of months in DOC, but the state and I agreed that he had already served his time in prison
Yeah.
and was entitled to immediate release. It took a little while, but within a few weeks, he was able to get out of
No,
jail.
I think we went through, Mr. Kilburn had extensive hearings, appearances, and everything was negotiated and a thorough colloquy, and I'm not going to allow any withdrawal plea, and I don't think any testimony,
Okay.
any testimony would change anything.
Okay. Does the state or the court have an objection to me filing a copy of the city ordinance that we referred to? I gave y'all copies at the hearing on the 8th, but we never filed it as an exhibit. I don't know that I need to for the appeal, but just in
State?
case.
The state has no objection, Your Honor.
All right, I think he filed it already.
Okay.
didn't he?
Well, for the
Well, if he
record.
didn't, go ahead and file it.
Okay. For the record, it's going to be marked as Defense Exhibit Number 1, and this is a copy of the City of Crestview ordinance that was referred to in the defendant's motion to withdraw plea. Give it to you or to the clerk?
Or it's admitted into evidence.
So at this time, for the record, the court's denying our motion for reconsideration?
Yeah, if
Okay.
you wouldn't mind, state, send me an order.
Okay.
Thank you, Your Honor.
Thank you, Judge.
Thank you. What about Mr. Kuntz? Come on up, Mr. Coon.
That's mine, Judge. It's a Williams rule. Notice it's scheduled for 2 o'clock. He's here. So we can go ahead and proceed on that at the courts.
I'm ready if you are.
That's fine, Judge. Judge, basically the state is, Mr. Koontz has 2 cases. Let me get my microphone.
Do y'all need to sit down at the table?
I'm good with that, but Mr. Koontz needs to sit down as well. He's got 2 cases, Judge. They both involve similar facts. The state, he's scheduled for trial in November on the first of the 2 cases. At this point, it looks like both cases are ultimately going to have to go to trial. The attorney's office is wanting to, in the trial of, we'll call it Case A, elicit the facts in Case B as similar fact evidence. I object to that. The basis of my objection is really, one, there's been no determination beyond a basic probable cause determination at the time, either of the warrant or first appearance, with regard to whether or not Mr. Koontz did these things in either of these 2 cases. Secondly, it's a situation where, because it's the exact same offense and the nature of offense, which is, it's the situation where he's alleged to have chatted up adult law enforcement officers thinking that they were children and attempting to seduce them, that the prejudicial impact of this almost identical offense would outweigh any probative value. And so that's largely the basis of the objection. I've looked for a case specifically dealing with the situation where another criminal event that's virtually the same thing, and I'll tell the court right now, it's going to be the same defense in both cases, that's virtually the same thing, is being used as substantive evidence in another case, even though there's been no determination either by plea or by trial of any sort of guilt in that case. And of course, the prejudicial impact of it is going to really lean more towards showing propensity or bad character, rather than it's going to be showing any of the permissible items under the Williams Rule statute, such as absence of mistake, knowledge, common scheme or plan, any of those things.
Doesn't require a conviction to be similar fact or similar fact evidence, is my understanding.
I have looked for the case that I thought I saw many years ago that said that, and I have not been able to find it in all candor with the court. But it's my position that right now all we have is sheer probable cause, and if we're going to get it to beyond that point so that it can be used, then either the state should need to show it in a hearing such as today, or it's no longer, it's going to become a feature of the trial, which it cannot do under Williams Rule, rather than just some evidence of one of those other indicators. I'll also point out that there's nothing so distinctive in either of these cases that's so unusual compared to other similar chatting up law enforcement officers on the internet cases that would satisfy that almost fingerprint similarity between the two that you need for some portions of the Williams Rule statute to apply.
What does the state say?
Judge, first, given this case might be a trial case, next cycle we'd ask that the TV be turned off.
All right.
Separate from Williams